Mr. Johan Marais was convicted on the 12th of November 2024 following his guilty plea on account of murder. The accused was at the time of the commission of the offense a member of the then apartheid South African Police, attached to the reaction unit and was a section leader. The deceased was a student activist and was a leader in various student formations opposed to the regime the accused served under. The deceased was shot and killed on the 24th August 1987 at his parental place at number 999 Lambert Street, Davidton. In 1966, the General Assembly labeled apartheid as a crime against humanity, open bracket resolution A, numeral figure 21 of 16 December 1966, close bracket, and in 1984, the Security Council endorsed this determination, open bracket, resolution 556, 1984 of 23 October 1984. The International Convention on the Suppression and Punishment of the Crime of Apartheid, in bracket Apartheid Convention, was the ultimate step in the condemnation of apartheid, as it not only declared that apartheid was unlawful because it violated the Charter of United Nations, but in addition declared apartheid to be criminal. Article 1, subsection 1 of the Apartheid Convention makes the following pronouncement, open quote, the state parties to the present convention declare that apartheid is a crime against humanity and that inhuman acts resulting from the policies and practices of apartheid and similar policies of racial segregation and discrimination as defined in Article 11 of the Convention are crimes violating the principles of international law, in particular the purpose and principles of the Charter of the United Nations, and constituting a serious threat to international peace and security. 2. The state parties to the present convention declare criminal those organizations, institutions, and individuals committing the crime of apartheid. Article 2 provides, for the purpose of the present convention, the term the crime of apartheid, which shall include similar policies and practices of racial segregation and discrimination as practiced in Southern Africa, shall apply to the following inhuman acts committed for the purpose of establishing and maintaining domination by one racial group of persons over any other racial group of persons and systematically oppressing them. A, denial to a member or members of a racial group or groups of the right of life and liberty of person, Roman figure 1, by murder of members of a racial group or groups. 2, by infliction upon members of a racial group or groups of serious bodily or mental harm, by the infringement of their freedom or dignity, or by subjecting them to torture or to cruel, inhuman, or degrading treatment or punishment. 3, by arbitrary arrest and illegal imprisonment of the members of a racial group or groups. B, deliberate imposition on a racial group or groups of living conditions calculated to cause its or their physical destruction, whole or in part. C, any legislative measures and other measures calculated to prevent a racial group or groups from participation in the social, economic, and cultural life of the country, and the deliberate creation of conditions preventing the full development of such a group or groups, in particular by denying to members of a racial group or groups human rights and freedoms, including the right to work, the right to form recognized trade unions, the right to education, the right to live, and the right to return to their country, the right to a nationality, the right to freedom of movement and residence, the right of freedom of opinion and expression, and the right to freedom of peaceful assembly in association. D, any measures, including legislative measures, designed to divide the population along racial lines by the creation of separate reserves and ghettos for the members of a racial group or groups, the provision of mixed marriages along members of various racial groups, the expropriation of landed property belonging to a racial group or groups or to members thereof, exploitation of labor of the members of a racial group or groups, in particular submitting them to forced labor. F, persecution of organizations and persons by depriving them of fundamental rights and freedoms because they oppose apartheid. Close quote. The Constitution of South Africa, in its preamble, recognized the injustice of our past and honor those who suffered for justice and freedom in our land. The Constitution was adopted to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. The adoption of the Constitution led to promulgation of legislation aimed at dismantling and repealing racially based laws. In his book, S.S. Tarablanche, 3rd edition, A Guide to Sentencing in South Africa, pages 151 to 152, formulates basic principles according to which sentence is imposed and provide that 1. The sentencing court has to impose an appropriate sentence based on all the circumstances of the case. The sentence should not be too light or too severe. 2. An appropriate sentence should reflect the severity of the crime while at the same time giving full consideration to all the mitigating and aggravating factors surrounding the person of the offender. In other words, the sentence should reflect the blameworthiness of the offender or be in proportion to what is deserved by the offender. And 3, an appropriate sentence should have regard to or serve the interest of society, the third element of the Zin triad. The interest of society can refer to the protection of society needs or the order of peace it may need, or the deterrence of would-be criminals, but it does not mean that public opinion be satisfied. 4, in the interest of society, the purpose of sentencing are deterrence, prevention, and rehabilitation, and also retribution. 5, rehabilitation should be pursued as a purpose of punishment only if the sentence actually has the potential to achieve. And 6, mercy is contained within a balanced and humane approach to consideration of the appropriate punishment. The accused refused to testify in mitigation of sentence, but led evidence of a clinical psychologist and Mr. Mathi, who compiled a consideration of correctional supervision as a sentence report. Ms. Clark, clinical psychologist, in her report detailed the personal circumstances of the accused, that is currently 66 years old. His mother gave birth while she was a grandfather forbade his mother to get married to the accused mother, as he was a very strict person. His mother was also chased out of their house. The accused was then adopted by his parental aunt and her husband. His adoptive mother died 20 years ago from smoke inhalation, and his father 3 years ago from natural causes. He has adopted siblings, a sister and 3 brothers. The accused found out that he was adopted when he was 16 years old. 3 of his adopted siblings have since died, and the only surviving sibling is his sister, who is currently 73 years old. The accused described his parents as alcoholics and a family home characterized by domestic violence. The accused grew up in a small holding, and the family moved around a number of times that led the accused attending various primary schools. He grew in a Christian family and only had one friend as he was growing up. He never experienced any abuse in his childhood life and described his childhood as being happy. He talks of his love for his .22 rifle that he used to shoot at birds and will cook such on fire after the shooting. The accused attended his high school at Huguenot Boer School in Springs. He left school at 16 years when he was in grade 11 after he obtained permission from the school board to go to the police college. In the police service, he completed matric national examination when he was 17 years in 1976. He did several police courses with his times in the police. Accused took a discharge from the police in 1981 and gained employment at Carlton Paper as a repulper. He left the employment after 6 months and joined the Rhodesian Light Infantry and worked there for a year. He then rejoined the South African Police, and that is when he was stationed at the Riot Reaction Unit in Benoni. Accused was in and out of the police and worked at Sun City Entertainment Center in Ufud, also known as Operation K or Swapol Coin, based in Rondo. He was also in the then Southwest border 4 times in 3 months slots. In 2004, after taking the exam, worked as a state agent, mainly selling plots and farms. He also started his own company, reclaiming tungsten and other precious metals from the mines. He also had a spaza shop, cash for scrap business, second-hand / antique shop, and in 2010 he published a book called State Bomb, a policeman Sevare Ferhar. The accused's first marriage was in November 1987 and divorced on the 22nd of September 2003. He attributed such partly to his drinking habit. 2 sons were born out of that relation and 1 stillborn child. He had a relationship with 2 women after such divorce and is currently not married. Accused as a child, to be precise, when he was 6 years old, he was involved in a motor vehicle collision and suffered head injuries. He also collided with a hole and a metal pole when he was 8 years old. He has a sharp nail on his right leg during his time with Ufud. He also suffered a head injury on his right hand side when the police car he was traveling in ran over a landmine. He also sustained a head injury when he was hit with a rock during his training as a police officer. He had a Bell's palsy when he was 8 years old. He has fainting spells but does not know the source of such. He was diagnosed with gout when he was 31 years old. The medical records seen by the clinical psychologist indicate that the accused was seen in an outpatient department on the 11th January 2024 for a swollen and septic toe, which he had for 3 months after defaulting from treatment because of lack of funds. This resulted in him being admitted into the hospital, and the abscess was drained and eventually discharged on the 19th January 2024. His gout ailment is described as severe on his right foot, right knee, and right elbow, which also affected his left knee. He has a suppurating sore on his right toe, which is not healing, and that makes walking difficult for him. He is currently on chronic medication for gout. Accused experienced bout of depression and had attempted suicide on 3 different occasions. The death of the deceased in this matter was one of the causes. This led him in having a charge a change in his eating and sleeping patterns. Accused was admitted in a psychiatric ward where he was seen by a psychologist, psychiatrist, and a social worker, but was discharged without a diagnosis after his second suicide attempt. His two adopted brothers died of suicide. Accused used to have a drinking problem, but he now occasionally drinks alcohol. He stated that the accused has remorse and regret. He feels differently now, and if he could go back in time, he will never do it. He believed that the deceased at the time was a terrorist. The killing of the deceased for many years, but in recent years he attempted to disclose that to the police and then contacted a journalist from the report. The accused is a first offender. It is also stated that the accused does not pose a risk to the society. At this point, it was then recommended to service. Second witness for the defense was Mr. Johan Marais from the Correctional Services, who compiled a suitability report in relation to correctional service. He stated that the accused is currently unemployed on a SASSA pension pension beneficiary and also receiving small pension, no amount stated from Sanlam policy. He stays in a property which is a rental property belonging to Ms. Labet, who also confirmed such. Accused has good ties with his two sons. One of his sons is staying in China and the other one in Niger, South Africa. Accused does not have a previous conviction, has no history of violation of parole conditions, escapes, and absconding. Accused uses alcohol on occasions and is not smoking or using drugs. Accused is getting emotional support from his family and is also financially supporting him. If accused can be placed under correctional supervision, he will be strictly monitored for the entire duration of his sentence. In addition to that, accused will be obliged to perform community service. As a result, based on his analysis and evaluation, accused is considered a suitable candidate to be sentenced under correctional supervision in terms of section 2761H. He then table proposed condition in terms of section 52 of the Correctional Service Act 111 of 1998, which includes house detention, community service. Further, that the accused can seek employment, takes up and remain employed, participate in mediation/restorative justice system between victim and offender, or in family group conferencing, restricted to one or more magisterial district, live in a fixed address, refrain from using alcohol or illegal drugs, refrain from committing a criminal offense, refrain from visiting a particular place or places, refrain from making contact with a particular person or persons, refrain from creating a particular person, refrain from threatening a particular person by words or actions, be subjected to monitoring or any other condition as may be appropriate can be made. Excuse me. After the evidence of the two witnesses, accused then handed in a letter he wrote to the family of the deceased asking for forgiveness for his actions, dated the 13th January 2025, which was admitted into evidence as Exhibit D. The accused then closed his case in mitigation of sentence. The state also led evidence of two witnesses, the sister of the deceased, Ms. Algeria Kusaka Nyoka, and Mr. Gugulake Exodus Nyakan, who was sleeping in the same room with the deceased before he was murdered. Ms. Nyoka testified she is a firstborn in a family of 7 children and the deceased was the fourth born. In 1987, when the deceased died, he was 23 years old. The deceased was a student at Mabuya High School, the Winston at 10, now referred to as grade 12. She confirmed that the deceased was a student activist, member of COSAS, South African Youth Congress, organizer of the East Rand Transvaal Student Congress. He was also the president of the Student Representative Council at Mabuya High School. The family was conscious of the political activities of the time and was sensitive to the happening under the apartheid regime. Their family was targeted because of their political activism, and they saw many police raids conducted at their family. In 1987, she was 32 years old but still residing at her parental. The deceased was arrested in 1985 for public violence and arson, but together with co-accused were not found guilty. He was also arrested in 1986 under the state of emergency without a trial. The day the deceased was murdered, there was a funeral at their diagonal front neighbor, and when she went home to sleep, she did not see the deceased. It was only after the deceased was murdered that they realized he was with 3 other young men in the room. They heard footsteps in the yard at around 2:30 a.m., and that could tell that many people were in. After the death of the deceased, his body was taken without them being informed where the body was taken to by the police. They only saw a pool of blood on the bed he was sleeping on, and they only saw that in the morning at approximately 5 or 6. They went to the Davidton police station there, but they were told to go to the Benoni police station and look for Major van der Berg, as he was in charge of the operation. They could not get assistance at the Benoni police station, and it crossed their mind that they should go to the government mortuary. That is where they found the body of the deceased and saw a bullet hole on the forehead, and the nose was covered with blood. The incident impacted negatively in the family, as the deceased was still young and they were expecting bigger things from him. They had hoped that he would go to the university and study. At the time of the funeral of the deceased, they were given restriction orders by the then government and told that there is a possibility that they cannot get the body of the deceased, as he died in police custody, and the South African Council of Churches. They had to delay the burial of the deceased, as post-mortem was conducted by both the state and private pathologists. Private pathologists' report indicate that the deceased died from 12 bullet wounds, which were centered around the head, chest, and hands. The funeral procession of the deceased was surrounded by a large contingent of police officers driving in police cars, and specific traveling routes were demarcated by the police for such purpose. There was an inquest conducted relating to the death of the deceased from 1988 to 1999, and it was the court's finding that the police were acting in private defense because of the information they received that the deceased was a terrorist. The deceased's father died with a broken heart in 1992, 5 years after the death of the deceased, without answers as to what happened to the deceased. His health deteriorated and was diagnosed with high blood sugar, diabetes, growth on the kidney, and 3 months after removing it, he passed on. His mother was also affected by such and was diagnosed with high blood. That led to the amputation of her leg and was wheelchair bound when she passed away 4 years later. She took the matter to the Truth and Reconciliation Commission, TRC, in 1996 and made a submission. The case was referred for public hearing in 1997, February, and she testified in the TRC. The accused and the People who were with him at the time of the death of the deceased did not participate in the TRC process. In 2019, she saw an article in the City Press and the report, and in the article it was reported that the accused had made a confession relating to the death of the deceased, and that is how the investigations in these matters unfolded. The deceased did not have any dependents. The accused never came to their family and apologized, but they did receive a letter dated 13 January 2025 following his guilty plea. Their plea is for accused to assist in the other matter which relate to his co-accused before trials were separated. She is of the view that the accused is worried about himself and not them. The second witness for the state was Mr. Gugulake Exodus Nyakani, who testified that before the day of the death of the deceased, he did not know him. He attended a funeral at the deceased neighbor and together with his friends were housed to sleep at the deceased room. There were 4 in the room, being himself, the deceased, Excellent, Ntembu, and Esten. Esten was sharing the same bed with the deceased, and he was sharing a bed with Excellent. Not long after they went to sleep, they heard a bang at the door and people saying, "Open, we are the police." They forcefully opened the door, and upon entering the room, they asked who Caiphus was, and the deceased responded by saying that he is Caiphus. He saw 4 police officers entering the room, and Aston Excellent himself were taken out of the room, forcefully dragged. The police officers were covering their faces with balaclavas. They were ordered to lie on the ground next to the deceased room, and he was stomped on his face. He then heard a lot of gunshots, and they went off, and he could hear movements inside the yard. He could hear the police asking Caiphus Nyoka, the sister of the deceased, who she knew before the shooting incidents, who are their names, and after that they were told to stand up and go and wear their clothes. They were then handcuffed after getting dressed and taken to Devontain police station. There was a lot of police officers, which included municipality police and police who were wearing plain clothes at the scene. They were taken to a room and were made to sit on the floor guarded by a police dog. Later on, a police officer wearing a balaclava entered that room and wrote on the board, 999 Lambert Street, Caiphus Nyoka executed, hands of death, and also wrote a number of shots, but he cannot exactly remember the number of shots written. He was made to read what was written with the firearm pointed to his head. He was poured with boiling water over his head when he requested drinking water. The incident disturbed him and hurt him a lot, as it was his first time to hear shots fired at such close range. He has just met the deceased, and within a short time he is murdered. The thought of being taken half naked outside embarrassed him. He did receive counseling following what he witnessed. The state closed its case after the testimony of Nyakam. The accused found himself standing a trial for a murder which was committed almost 30 years back in time. Accused at that stage was only 4 years after rejoining the police. After he left in 1981 in the police, after going for training at the age of 16. He completed his matric while serving in the police. He was still young at that stage, but already had a rank of a sergeant. He got married the same year he committed this murder in November, which is a period of approximately 3 months. It is not disputed by the state that the accused, in his line of duty as a police officer and in the military, was exposed to serious violent encounters. He fought in the border as a member of UFUT and in Angola. He has experienced as a victim of violent encounters and survived limpet mine attack and other violent incidents. As a leader and a member of the riot unit, he was deployed to what was classified by the apartheid regime as black townships in the East Rand. He was exposed to necklace killing, where a tire is placed around the neck of the victim and those with petrol still alive. He was exposed to what was referred to as black-on-black violence, wherein victims were hacked and assaulted with knobkerries and made to dispose of such bodies. He had to collect mutilated bodies which were placed on rail tracks to be run over by a moving train. He had a serious drinking problem and a violent behavior that resulted into the dissolution of his marriage. The accused kept quiet for a prolonged period of time without telling any person about his involvement in the murder of the deceased. He lied under oath together with his colleagues at the inquest proceedings that the deceased was armed when he was murdered, which resulted in the court finding that they acted in self-defense when murdering the deceased. He was aware of the TRC hearings, as he stated in his clinical psychological report that he saw that on television, but failed to participate in that process. He failed to reach out to the family of the deceased to ask for forgiveness, despite saying that the death of the deceased troubled him for a very long time. He only wrote a letter to the family of the deceased after he was convicted in November 2024, and the letter is dated 13 January 2025. He only started speaking of his involvement in a murder of the deceased for the first time in 2019. However, the family of the deceased acknowledged that it is because of him coming out and indicating his involvement that the investigation in this matter unfolded. This is despite that already in March 2024, there were negotiations between the state and the defense relating to the plea of the accused. An accused was legally represented at that stage. There was an opportune time through his legal representative to write a letter and formally apologizing to his section to the family of the deceased. The accused gave a narrative of the events of the 24 August 1987, which is a direct opposite of what he stated in his section 112.2 statement, in bracket guilty plea statement, close bracket. He mentions the presence of people who were arrested at Davidton police station, which concealed impact mines and hand grenades. That the deceased had plans to attack the Davidton police station the next day, and that he was highly trained and has also been training military other activists. Whereas in his guilty plea statement, he mentioned that they were briefed to arrest the accused. He does not mention the order to kill the deceased, which was given by Sergeant Stander, but he said that immediately after Engelbrecht left the room, he fired shots and Stander also fired shots. The accused attempted to take his life on 3 different occasions and attribute that amongst to the death of the deceased and his involvement. The first suicide attempt related to the divorce matter, and it was in 2003. His second suicide attempt was in 2019, and he does not state the reasons for his attempt to take his life. His last attempt to take his life, no date stated, was when the police officer who was supposed to have come and fetch him for a court appearance failed to fetch him for that appearance at court. He thought that he will be arrested for failing to appear at court. I do not know why accused had to be transported to court for his appearance because he was not in custody at that time. However, on a proper look of the reason for his attempt to take his life, they have nothing to do with the death of the deceased and are actually for his own personal problems. The deceased died a brutal, careless, and painful death. The post-mortem report, which was admitted into evidence as Exhibit B, indicates that the deceased died as a result of being shot multiple times. The deceased was lying on the bed when he was shot. According to the guilty plea, he was shot at a very close range by the accused and his colleagues at a range of 1 meter. The deceased, despite the contention by the accused that he perceived him as a terrorist, did not pose any danger to them. Neither of the people in the room were armed, and no weapons were found by the police after the deceased was murdered in that yard. The right to life of the deceased was taken away in a flagrant manner in disregard of such right, in defense of the policy that was declared a crime against humanity by the international community. Ms. Clark argues that the accused was under orders when committing the offense, but on a proper reading of Section 112(2) statement, there was no order for the accused to kill the deceased, but to effect the arrest. The accused is the one who decided to kill the deceased after he was identified by Engelbrecht. Even though there was an instruction to kill the deceased, it was an unlawful instruction which accused was not obliged to follow. The crime was committed when a political environment in the country was at a boiling point. We are now in a democracy, and the country is at a time experiencing service delivery protests, fees must fall protests, etc., etc., and at times they tend to be violent, and at times result in a loss of life. What happens in the 1980s relating to police brutality must not be repeated in the current milieu. The right to assembly, freedom of association is enshrined in the Constitution, and the police must not be weaponized to suppress those rights. In the matter of State versus Palo and others, 1999 ZA SCA 84, in bracket 19 November 1999, the Supreme Court of Appeal, when dealing with sentence involving police officers who committed offenses, stated that, unquote, a police officer who places supports loyalty to colleagues committing crimes above his or her police duties should know that the courts of law will take on extremely serious view of such conduct and will not hesitate to impose a severe sentence, close quote. Members of the committee and the general population of South Africa has an interest in the outcome of the trial of the accused. However, it is not an object of sentencing to satisfy public opinion, but to serve public interest. There is expectation from the members of the community for such crime to be punished harshly, which is, in my view, a reasonable expectation because the crime was committed by police officers. On the other hand, the court must not lose sight under which such crime was committed. In quoting statement 2017, Ms. Clark stated that, unquote, the South African Police SAP were at the front line enforcing the state of emergency declared in the 1980s. The SAP was the nationalist most important pillar of strength. In essence, the police were the first line of defense against those who threatened the system. It was the police force that had to physically implement their state policies, close quote. It is against this background that apartheid was not only rejected by the South African citizen, but by also the international community. The apartheid convention was already in place at the time of the murder of the deceased. In the matter of State versus Ntlagaza, 1997, Volume 2, All SA Report 185A, Harams J, when dealing with the interest of the community society, stated that, unquote, the object of sentencing is not to satisfy public opinion, but to serve public interest. A sentencing policy that caters predominantly or exclusively for public opinion is inherently flawed. It remains the court duty to impose fearlessly an appropriate and a fair sentence, even the sentence does not satisfy the public. In this context, the approach in State versus Makwanyane and another 1995 Volume 2 SACR 1CC paragraphs 87 to 89 per Chaskelson applies mutatis mutandis. Public opinion may have some relevance to the inquiry, but in itself it is not substitute for the duty vested in the court. The court cannot allow itself diverted from its duty to act as an independent arbiter by making choices on the basis that they find favor with the public. Further, that given the current levels of violence and serious crimes in the country, it seems proper that in sentencing, especially such crimes, the emphasis should be on retribution and deterrence. Close quote. In State versus Karg, spelled KRAG, 1961-1, SA 231A, it was said that if sentences for serious crimes are too lenient, the administration of justice may fall into disrepute and injured persons may incline to take the law into their own hands. The death of the deceased did not only negatively impact on his family, but also the community that he served as a student activist. And most importantly, Mr. Nyakan, who witnessed the cold-blooded killing of the deceased when he was still young in his life. The parents of the deceased died before finding closure. The deceased sister testified how he was loved by the community and that if he was alive, he was going to be a politician and champion the fight against corruption. The murder was committed before the coming into effect of Act 105 of 1997, which prescribed life imprisonment and 15 years sentences for specified crimes. Murder under these circumstances does not fall under the purview of Section 51(1) and subsection 2 of Act 105 of 1967, which prescribed life imprisonment and 15 years imprisonment. In State versus Kekana 2019, Volume 1, SACR 1, SEA at paragraph 22, the court stated that, unquote, the provision of the CLAA do not create different or new offenses, but are relevant to sentence. Thus, murder remains murder as a substantive charge, irrespective whether it's Section 51(1) or Section 51(2). It follows that there can never be a plea to such a non-existent charge. Close quote. Sorry. In State versus Lohoa, spelled LGOA, 2003, Volume 1, SACR 13 SCA at paragraph 18, the court, when dealing with penal jurisdiction, stated that, unquote, it is correct that in specifying an enhanced penal jurisdiction for particular forms an existing offense, the legislature does not create the new type of offense. Thus, robbery with aggravating circumstances is not a new offense. The offenses scheduled in the minimum sentencing legislation are likewise not new offenses. They are but specific forms of existing offenses, and when their commission is proved in the form specified in the schedule, the sentencing court acquires an enhanced penalty jurisdiction. It acquires that jurisdiction, however, only in the evidence regarding all the elements of the form of the scheduled offense is laid before verdict on guilt or innocent, and the trial court finds that all elements specified in the schedule are present. Close quote. Simply put, the introduction of Act 105 of 1997 was mainly done to prescribe particular sentence for specified crimes, but the charge of murder does not change its content, it remains murder. Evidence accepted by the state shows that the murder was committed by a group of people acting in common purpose or common concept involvement of common purpose. Based on the admitted evidence, it is difficult to make a finding that the murder was premeditated or planned. But I find it difficult to understand that an operation to arrest an individual can involve such a high number of police officers from different police units if the intention was not to kill. Ms. Simpson, on behalf of the accused, contended that the murder is not premeditated, as the intention to kill the deceased was only formulated when the accused and his colleagues were inside the room of the deceased. Ms. Simpson further contended that the court should consider imposing a sentence in terms of Section 276(1)(h) or 276(1)(i), taking into account the age of the accused, the health condition of the accused as he is suffering gout ailment, which can affect his mobility if incarcerated for a lengthy period of time, the fact that he is the one who confessed to a journalist, which resulted in this matter being investigated and the accused being prosecuted. Mr. Davana, on behalf of the state, contended that the murder is premeditated. Accused showed no remorse. He failed to come forward at the opportune time and disclose his involvement in the murder of the deceased, and for that, the accused must be sentenced to life imprisonment, alternately 25 years imprisonment. It is with no doubt that at 66 years, the accused is of advanced age. Both parties agreed that the crime is punishable with a custodial sentence, though on different terms. It is also tried that there is no penal provision for the murder committed, and the court has inherent penal jurisdiction to impose any sentence based on the circumstances of this matter. In State versus Class 2018, Volume 1, SACR 643cc, the Constitutional Court, when dealing with appeal of a 50-year-old accused who had already served 4 years at the time when the matter was heard, stated, unquote, "In my view, the applicant's personal circumstances pale in relative insignificance when regard is had to the seriousness of the offenses and the need to protect the public," close quote. In State versus Haywood, 2017, Volume 1, SCR 309 SCA, the court, when sentencing the accused, who was 75 years old, for crimes committed 30 years back, stated, unquote, "The appellant's poor health is certainly a matter which must be considered, and so is his advanced age. However, as the court observed, he does not suffer from a terminal or incapacitating illness, as he leads an active life, which includes personally and successfully running a commercial citrus farm, and is even able to drive his employees home daily. It was also not disputed that the medical treatment and the care that he requires would be available in prison. Regarding his age, while courts have considered oldness as a mitigating factor, it is certainly not a bar to a sentence of imprisonment," close quote. The health of the accused was also presented as a mitigating factor. The hospital record shows that accused was last treated for the gout ailment in January 2024, and this was as a result of the accused defaulting on his treatment. The clinical psychologist, though not a medical doctor, acknowledged that the gout ailment can be treated in a correctional facility. It shows that if accused ailment is properly treated, it's controllable and it will not affect his mobility or incapacitate him. Since the matter has commenced last year, there was no instance when accused complained of any difficulty relating to his condition. Also, accused expresses love for gardening, which indicates that he leads an active lifestyle. Mr. Davana, in argument, contended that most of the evidence in this matter was destroyed. The exhibit that they used to prosecute the accused was found from the attorneys who represented the family of the deceased at the inquest hearing. Accused, to a large extent, in disclosing his involvement in the matter of the deceased, assisted in the investigation of the matter, and also for him to be criminally prosecuted. Ms. Simpson contends that if the accused could not have disclosed his involvement to the journalist, there was not going to be a case against the accused. The submission may be correct, but it's the ex-wife of the deceased who told the accused to approach a journalist and disclose his involvement, and that was in 2019. The accused, after disclosing his involvement in a murder and with full knowledge that the Hawks, that is the unit in the police, is looking for him, decided to go and stay in his brother's plot without handing himself to the police until he was traced to that plot by the Hawks. It is further contended by Ms. Simpson that the accused is remorseful for his actions, an averment which finds favor in the clinical psychological report. The Supreme Court of Appeal in State v. Machichi, 2011, Volume 1, SACR 48, Paragraph 13, when dealing with remorse, stated, unquote, "There is moreover a chasm between regret and remorse. Many accused persons might well regret their conduct, but that does not, without more, translate to genuine remorse. Remorse is a known pain of conscience for the plight of another. Thus, genuine contrition can only come from an appreciation and acknowledgement of the extent of one's error. Whether the offender is sincerely remorseful and not simply feeling sorry for himself or herself of having been caught is a factual question. It is the surrounding actions of the accused rather than what he says in court that one should rather look. In order for the remorse to be a valid consideration, the penitence must be sincere and the accused must take the court fully into his or her confidence. Until unless that happens, the genuineness of the contrition alleged to exist cannot be determined. After all, before a court can find that an accused person is genuinely remorseful, it needs to have a proper appreciation of inter alia, what motivated the accused to commit the deed, what has since provoked his or her change of heart, and whether he or she does not indeed have a true appreciation of the consequences of the actions. There is no indication that any of this, all of which was peculiarly within the respondent's knowledge, was explored in this case, close quote. According to the clinical psychologist's report, the accused was informed by standard after murdering the deceased that he will be protected. The inquest finding is one of the manners in which the accused was protected. This firearm was taken away from him after committing the murder, and the intention, in my considered view, was to fulfill the promise they made to protect him. Fast forward into democracy, and in the spirit and ethos of the Constitution, TRC proceedings were initiated where murderers of the apartheid era were given an opportunity to disclose their evil past in return of indemnity from prosecution, but the accused deemed it not necessary to participate in that process despite being fully aware of such. It's only in 2019, after attempting to commit suicide, that the accused decided to approach a journalist and disclose his evil past. The evidence does not indicate that what led to change of heart. The accused does not take into confidence and tell what motivated him to commit the crime. It is appreciated that the accused was in the police that was in defense of apartheid policies, but he was not the only officer who was part of the operation. All the police officers who he mentioned that were there did not all fire shots at the deceased, but himself and Standard. The order was simple and straightforward: to arrest the deceased. 12 shots are fired at the person who was sleeping. Accused also decided to give two stories to one story, one in the section 112(2) statement and one in the criminal psychologist report. He writes a letter of apology on the 13th January 2025 after having pleaded guilty on the 12th November 2024 to the family of the deceased, and this clearly means to me that the accused was preparing for his mitigation of sentence. There was nothing precluding the accused to reach out to the family of the deceased and apologized. The surrounding circumstances does not indicate a genuine remorse. The accused, fully aware that he did not participate in the TRC processes, which had this matter in 1987, waited for almost over 20 years to disclose what he did in 1987. I'm not persuaded that the accused indeed had a true appreciation of the consequences of his actions. A lengthy period of time lasts between the time of commission of the offense, the investigation, and the prosecution of the accused. It is appreciated that there was no way that the accused could be prosecuted for the case any time before 1994. The matter could also not be prosecuted immediately after the TRC hearing, as the accused did not participate in that process, and vital evidence was destroyed in the matter. This is only after 2019 that the matter gained full steam, and this was after a change in the investigating officers. The timeline is in total 37 years, but failure to prosecute the accused timely cannot be laid in the hands of the prosecution. The matter of David Supra, the court, when dealing with a lengthy time taken to prosecute the accused, stated, unquote, "It is indeed regrettable that it took so long to bring the applicant to justice, but this is not an unusual phenomenon in this type of cases, and despite the obvious difficulties posed by the delays, our courts have ably delivered just decisions. I'm not satisfied that the sentences imposed by the court are not appropriate, and that it exercised its sentencing discretion improperly. In my view, the sentence fit the criminal and the crime and fairly balance the compelling interest. Although the element of rehabilitation has little relevance here because of the appellant's age, the sentences would still serve the important purpose of sentence, i.e. deterrence and retribution. This court therefore has no right to interfere," close quote. Technical psychologists opine that the accused is a suitable candidate for rehabilitation, and a suitability for such sentence was assessed by Mr. Marais from the Correctional Service. Punishment is a custodial sentence, but on different terms. Correctional supervision as an alternative penalty to imprisonment can be imposed in any crime the accused has been convicted of. It has been imposed in murder cases, rape, fraud, and dealing and possession of drugs, to list the few. In State versus Samuels 2011-1 SACR 9 SCA, the court, when dealing with the imposition of correctional services, stated, unquote, "It is tried that the determination of an appropriate sentence requires that proper regard be had to the well-known triad of the crime, the offender, and the interest of society. After all, any sentence must be dealt with on its own peculiar facts. It must also, in fitting cases, be tempered with mercy. Circumstances vary, and punishment must ultimately fit the seriousness of the crime. The interests of society are never well served by a harsh or a lenient sentence. A balance has to be struck. Sentencing court must differentiate between those offenders who ought to be removed from society and those who, although deserving of punishment, would not be removed. With the appropriate conditions, correctional service supervision can be made a suitability severe punishment even for persons convicted of serious offenses, close quote. Based on the circumstances of this matter, I'm not persuaded that the accused is a suitable candidate for correctional supervision. The sentence must fit the criminal and the crime, serve the interest of the community, and be blended with the measure of mercy. In State versus Ravi, courts are cautioned not to approach sentencing in a spirit of anger, because being human, that will make it difficult for the judicial officer to achieve that delicate balance between the crime, the criminal, and the interest of society, which is task and the object of punishment is one of him. Due to the advanced age of the accused, rehabilitation is no longer a consideration. The sentence that is going to be meted to you today is intended to serve two purposes: deterrence and retribution. In a clinical psychologist report, you indicated you want to write a book about your life after completion of your trial matter, and the time has now arrived. You will use the time to write a book and fully detail your involvement in the killing of the deceased. Also use the time in your book to educate South Africans who are still living in the racist past to embrace democracy and learn to live side by side with their fellow countrymen. It is unfortunate that the political heads of your time are not standing trial today, who are responsible for promulgating draconian and racist laws that led to you behave the manner you did 37 years back. I hope you will also use this opportunity to reflect, and hopefully you will change your mind and testify on behalf of the state in a matter pertaining to your former colleagues. Also use this time to influence those police officers who kill people, who opposed apartheid and are not yet detected, to come forward and disclose their part in those killings. Having said the above, I'm of the view that the sentence which I'm going to impose will fit the crime that you committed, and you now as a convicted criminal, the interest of society, and is blended with a measure of mercy. As a result, your sentence is as follows. May the accused stand up. For the crime of murder, you are sentenced to 15 years imprisonment. That will be your sentence. Yes. Court adjourns.
Long live the undying spirit of Caiphus Nyoka. Long live! Long live!